So we're getting this.
You watch. What your friends that whatever. Nothing. Now but then $1 and I will put it. This is the one.
Take him story. Jaji Jayunga. It's never one to take you out.
I'm not going to tell you now.
Join the South Several apartment. zino ensawo z'abantu mulimu kunyigiriza mu kifo kiki kifo
alina otambula mu kafande mpolampola mbeera ngaotaddemu
mbeera nkoze omujja mu bangi muba mu media same media house naye nemujja abantu
fano oyagala afando oyagala fano ayagala tugana mirimu gyakola kyagamba
ate bano abatudde bebafunza n'ekifo bakisibawawa kutundu kati namufunza ekifo badde bayimirira wano otadde wama naye nkitegeera naye kyenyanja nti omuntu yandibadde ayimirira wano olwedo abataddewo kati aba afunza kati webateeberera emabega nga mugamba fandalikanimona ba mu kifo kyange zinensawo ekiteziteeka wabwe
nsoyitawo kanso
Council video itu. Then I saw the council over camera. Council jambo Kasenga waliwo abalala Council waliwo abalala state nga waliwo abalala batudde abatali baganda bo.
Baganda
naye bano baganda bo.
judge needs to hear us that we are here. You guys are here. Yeah. So the judge needs to hear us. Maybe he doesn't know we are here.
never,
never, never surrender.
we shall
Never, never, never surrender.
never,
Never, never, never surrender.
we shall
Never, never, never surrender. 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 Never, never, never surrender.
Now give him another 5 minutes. If he hasn't come, we sing, no stopping until he hears that we are here.
freedom for all.
Application number 814 of 2025. Colonel retired Dr. Besigye and Hadebe retired versus Uganda.
You made these courts. My Lord, in order of representation for the party, for the state, it is led by Mr. Thomas Yachiko, Assistant DPP.
It's true, my lord.
Then Mr. Richard Billy Bumbuka, Chief State Attorney.
That is true, my lord.
Mr. George Igira, Senior State Attorney. My Lord, for A1 and A2, Mr. George Igira. My Lord, for A1 and A2, my colleagues who have come and are down in the cell, Miss Martha Karua, Senior Counsel. Miss Martha Karua, Senior Counsel. Mr. Elias Okubaako. Mr. Ernest Kalibala. Apollo Katumba, Miss Proscovia Mihira, Mr. Brian Mugunawe, Mr. Abu Baker, second Jacob, Mr. Tobias Kafusma, Kafuswa is Tobias Kafuswa. Kafuswa is KHA, FUSWA, Tobias Kafuswa, TOBIAS. Kafuswa, my lord, is KHA, FUSWA. My lord is Mr. Farouk Ahmed. Mr. Wanda. My lord, I am Frederick. Wanda is answer. My lord, I am Frederick. My lord, for A3. Mr. Simon Suga. And we have assisting me, Ms. Claire Maku. And Ms. Anita Namaku. Namakula. But my colleagues, some of who are not here, down their clients, the holdings there. They are these persons who are brought just in time. So just question that is allowed 5 minutes for consultation. Then we can proceed.
What is this podium?
For that, I'll ask Ms. Media to just take them.
Application number 814 of 2025, Captain Dr. Besigye and Advocate Besigye.
This application seeks two orders. The first one is the stay of proceedings, criminal session 335 of 2025. Pending the hearing and the determination of the constitutional petition 31 of 2025. The second, my lord, is for the applicant to be released from custody. My lord, as a consequence of this stay, order is granted. The evidence to support the
Senior application 282 of 2025, Kano Dr. Besigye and Besigye Besigye.
Yes, I will die out. Hello, the applicants in miscellaneous application 282. Took the decision to withdraw, say, to that effect, wrote a letter to the registrar of the court, registrar of this division. I believe that the letter is dated, I think, 20th of September 19. Yes. I'm aware that it was uploaded on the case file. I am aware that the application shows in the manner that the applicant
The prosecution has no objection. The respondents have no objection to this withdrawal.
Request out this application number 284 2025 is granted.
Criminal Senior application 814 of 2025, Arbiter Besigye Besigye and Arbiter Besigye Besigye.
And I will tell my lawyer that the evidence to support the application is in the affidavits. There are 5 of them. Two of them are in support, 2 are in rejoinder. There's a supplementary one. Before I get into the evidence, I wish to just make 2 points. First one is about the inherent powers of this court. In section 37 of the Judicature Act, this court has power to to grant absolutely or on terms and conditions it deems just. All the remedies that the party might seek my lord, from that inherent of the inherent jurisdiction of the court is where that inherent power comes. My lord, that power has been described as a residual power or a reserved power which the court can call upon or draw upon as the need arises, whenever it's just a victim to do so. And particularly to do justice to parties and to secure a fair trial between them. Those words are the words of Justice Seru in Kiza Aaron versus Uganda. Miscellaneous application 118 of 2025, page 21. And the second point, aside from the inherent power, is the question around discretion. So, although the orders sought are discretionary, the part of the court, the discretion has to be exercised judiciously. In other words, an exercise of judgment based on what is fair under the circumstances. A number of cases from this division have spoken about judicial discretion in the manner I have quoted. Lord, one of those is Keys and Aaron at page 23 and 24 of the ruling. My Lord, having addressed the court on its power and on the parameters of exercising its discretion, I will now move to the first order being sought. filed constitutional petition number 31, 2025. And the same is pending determination. My Lord, the petition, copy of the petition is annexed to the affidavit of the first applicant. It's marked D. My Lord, that petition seeks constitutional interpretation of various articles, including 28, 44, from which there cannot be any derogation. My Lord, the facts that give rise to that petition have to do with the experiences of the applicants and the view that has been formed that they may not get a fair hearing. My Lord, the petition is of great personal importance to them, but also great public importance. If the declarations they seek are granted, they would directly impact on criminal session case 335 of 2025. I know that may be the personal capacity, but the public importance, public importance aspect. The petition also challenges various rules that manage the process of recusal. As provided in the one, I'll just call it the recusal directions of 2018. They have a fairly long name, constitutional recusal. Judicial officers practice directions, recusal directions. So, my Lord, it serves both the public and the applicants directly. It also deals with matters of reference, the constitutional court aspects. Of a proper computation of time, the mandatory day of applications. whenever there are petitions of this nature ending the Constitutional Court, the guidance provided by the Supreme Court in the case of Charles Onyango Okubaako and Andrew Mujuni Mwenda, Charles Onyango Okubaako, Andrew Mujuni Mwenda versus Attorney General. And this Constitutional Appeal number 2 of 2002. The guidance, my Lord, has been and remains that the petition be given priority over other proceedings in the lower court, my Lord Justice Mulenga Stephen was gave the rationale for that approach. Which if I may paraphrase, my Lord, is that since the Constitution is the basic law, from which all laws and actions derive validity, where the constitutional validity of any law or action awaits determination, it is important for that determination be done, expedited, in order to avoid taking an action or applying a law whose validity is questionable. Although that position and the need to give preference to the petition was affirmed in the same case by the Chief Justice then, Justice Benjamin Odoki. It was also affirmed by Justice Sekoko as he then was. In that case, for right, the Constitutional Court had opted to have the lower court proceedings continue in determining the petition whenever they had an opportunity to do so. So my Lord, the law remains that because Kunyango has not been valid since 2004. The law remains that the petition should be granted precedence. My Lord, in this particular case, it is even more important because part of what this case is even more important because part of what the applicants are complaining about has to do with the tribunal itself. When a stay is granted using the inherent jurisdiction and the inherent power of the court, it is not the case that the court has made a final determination. Rather, it is the case that the court stay is giving an opportunity for the bona fide contentions of the petition to be determined so that a fair trial can be guaranteed. Lord, your brother Judge Mwata J, in the case of Chintu Muteza Felix versus Uganda, miscellaneous application number 10 of 2023. Was on the view number 10, 2023, stated that the applicant should show there is a real risk of serious prejudice. The stay is not granted. Which risk might lead to maybe to an injustice. My Lord, there are authorities exceptional circumstances. My Lord, the state might refer to maybe Agnes Nabutu, a few others, I'm not sure what they will say, but maybe 2 points to make about the exceptional circumstances. First one, that what the petition is complaining about actually presents exceptional circumstances. Because it goes to the root of the phrase fair and impartial tribunal in Article 28. And my lord, the second point to make about that particular authority is that does it cite Charles Onyango Obo anywhere? Therefore, is likely to have been made incurium. Because, my lord, we know that most of people are not overruled what the Supreme Court has said. My lord, on this first order, it is the very humble prayer of the applicant that based on the guidance of Charles Onyango Obo, and even if we were to apply that the applicants have demonstrated what is necessary for the court to exercise its discretion in their favor. As I have submitted, the matters go to the root of the question around fair hearing. And it's only the Constitutional Court that can deal with that question. Just for illustration, there is the famous case of Michael Kawasibu and what it eventually resolved. My Lord, imagine if Michael Kawasibu had in fact been tried. Being in prison for the duration that it took, that case to be jumped. The unfairness he would have suffered would have been too big to remain in any manner at all. My Lord, regarding the second order that is sought, here, just to emphasize one small point on the Charleston number of case. There was a decision of Route 2 versus Attorney General. Which had sort of said that the petitions can be stayed while other proceedings. What Charleston number was turned that around and settled. My Lord, I will move to the second round, the second order sort, which essentially, my Lord, is an offshoot of the first order. The court is minded to stay then we are also asking it to consider releasing the applicants from custody. My Lord, to do so, we must go over the grounds of bail that apply in this court. My Lord, as we all know, bail is temporary release pending trial. It's not a discharge of accused person. Simply means that the trial, if it is continuing, will take place when the accused is coming from their place of abode. My Lord, the most important consideration of the authorities coming out of this division that the court should be satisfied that the applicants will return. Court, as and when required, and to support the court in making that determination. Bail guidelines 2022 were put in place. My Lord, the guidelines are premised on one, the presumption of innocence. Number two, the right to liberty. Number three, the obligation on an applicant to attend court. Then the discretion of the court, and lastly, balance of the rights of the accused applicant and the interests of justice. My Lord, Direction 13 is a specific one that expounds on the various considerations that are important. Though there are 15 of them. But what is very important, my Lord, to indicate is that between the second last and the last one, there is what is called a coordinating conjunction. The word "or" means that an applicant does not need to demonstrate all the 15. After each consideration, there is a semicolon, at the end there is the word "or," which suggests you need not satisfy all. So, my Lord, the court determining whether the accused will come back to the court when required. The fixed place of abode is an important consideration. Both applicants have demonstrated in their affidavits what their fixed places of abode are. In the case of the first applicant, Bayinza LC1, Sambati Town Council. In the case of the second applicant, singular village cell in Makindi suburb of Besigye. They also attach copies of their national identity cards, letters from the LCJ persons in their respective places of abode. To speak to those facts. Along the second element that would help the court in determining whether the applicants will return has to do with sureties. I will address that at the end of the submission when I'm introducing sureties. Suffice it to say, my Lord, that sureties will be introducing have been found to be substantial in a previous application, but we will address that shortly. additional grounds have to do with the antecedents of the applicants. Maybe their personal circumstances first, which is their age. They are both over advanced age, 69 and 66, respectively. I know none of them has a conviction against their name. In the case of the first applicant, although he has previously been charged with this same type of offense, 2006, 2016, he also has no conviction against his name. No, he was discharged in 2006 case. The 2016 case was withdrawn by the state. But more importantly, of his antecedents, when he was granted bail in those two cases, he abided by the terms set religiously. Lord, the annexures to his supplementary affidavit contain proof of his antecedents. The case is at the nascent stage, so at the beginning. There is a possibility that it will take a while to resolve. Particularly because of the grave matters raised. Constitutional Petition 31, 2025. Lord, just to illustrate the point around delay, it is the first applicant affidavit in the joinder two documents were annexed as Proof G. My Lord, they speak to the processes in the Constitution. My Lord, that the first annexure drawn from you shows 26 judgments of the Court of Appeal 2025, but none of those have been filed in 2025. So the 26, 24 of them have taken between 10 years and 3 years resolved. We are not suggesting that the one, quarter one of 2025 will take 10 years, but it's just to illustrate that the other court is also quite engaged. Just by considering that this petition is 31, 2025 is another 30 before his that we have filed in this year alone. But we also annex a letter from the Deputy Chief Justice, part of Group G, which speaks to the prioritization of cases in the Court of Appeal. There, the delays caused perhaps by manpower limitations there. The other grounds, my Lord, are canvass, the likelihood to commit an offense, the applicant's state because they are not going to commit any offenses, they are not going to affect the witnesses. Pending charges, the first applicant has one, like the grant for several years, Grant Road, hasn't even reached the stage of no case once. But the second applicant has none. So my Lord, from the second order, bearing in mind the possibility of significant delay in disposing of the petition, yet proceeding without that disposal being done will prejudice the applicant. It is our humble prayer that the applicants be found have satisfied all the requirements of grant of bail, and that with light of possible stay will be admitted bail. Lord, if I may further quote to previous decision, Miscellaneous application 113 of 2025. Same applicants, yes, Uganda. The Lord, the court found this is your sister, just Esanyu, but the applicants have satisfied all the relevant requirements. These are some of the ones that will grant bail. But she declined based on one ground, which was essentially that investigations were being completed. Though that is no longer a position, since when the accused were committed 29 May 2025. So my lord, that ground itself is no longer it's my humble prayer, my lord, that you find the accused satisfied the requirements and to grant them bail. Now I will now proceed to the sureties. Now the courts have to say that sureties are sound. It is established that they are capable of ensuring or guaranteeing the applicant's appearance in court whenever required. My Lord, it is also the position that challenging the suitability of sureties should be based on factual grounds. But those are the views of your land brother in Hero Kisa. So challenging the suitability of sureties should be based on factual grounds. Then the idea that they should be sound. They are capable of ensuring or guaranteeing the applicant's appearance. My Lord, I will start with the first applicant and start with the Honorable Esanyu right hand. Honorable Esanyu and the resident Casa Village, in the parish. My Lord, Semuju Nanda Ibrahim. As the Lady Justice Kanya found, he is still 52. He's a resident of Okasa Village, Chirina Parish, where the division has his national ID and a letter of introduction from his LC. He's also the member of parliament for Jira municipality. He's a close friend of the first. Second, surety is the Honorable Mohindo Harold Tony. The Member of Parliament for Konzo County, Mohindo Harold Tony. Member of Parliament for Conzo County East. Is age 52. He's also a close friend of the first applicant, who has also better national ID. President. The third is the Honorable Philip Wafula Okutu. That is a close friend. The first applicant is a resident of 12 Matters Crescent. In Tinda Salim Bay Road. So 12 Matters Crescent in Tinda Nakawa Division. Lord, the three sureties have undertaken to ensure that the first applicant appears as a required. They have the capacity to ensure their friend and colleague abides by their terms. First two, Gail Yolan's sister, Justice Kanda, found that they were able to exert influence over Papa to ensure that takes court. When the first applicant himself, one of the most obedient persons who work with faith of this. For the second applicant, the first surety for this applicant, second applicant, is his brother, Kato Isa Utale. He is the resident of Nansana Zone 8, Zone 7, Zone 8. Chain 1, or Chain Ward, sorry. Nansana Zone 7/8, Chain Ward, Nansana Division, Nansana Municipality. Has presented national identity card, who it is, God is a surveyor by profession. He's a brother of the The second authority is Halima Mutale Najika. Halima Mutale. She is a resident of Chisikula village, Mutumbu parish, Makindi division. Represented our original national identity card. She's a business woman by profession. And lives at the same location as I know a small correction at top is the amp of the certificate applicant's certificate. Sometimes arguments are made that charities are younger than the ones they stand for and so on. They are not sound. Again, you learn dealt with that point very well. Saying that to suggest that we older to set a dangerous precedent for seniors. They never find truth at all. Older than good. Basically, the two second applicants' societies, the letters, those letters, haven't gotten to us yet. We have a critical whether that we can be supplied. One of them had at least been approved already in application 113. And that's a small administrative matter that can be worked with easily. My Lord, as I wind up, it is my humble prayer that God be pleased to grant both orders sought. On terms that God makes us fair findings beside the key authorities. And for the record, my name is Okubaako. Regarding the first prayer of the court assault, my Lord, I would like to refer this honorable court to the authority Besigye Hassan versus the Attorney General. It's Constitution Application number 9 of 2013. Where the Constitutional Court held that stay of the proceedings like in the instant circumstances, my Lord, is a constitutional command. It's a constitutional command. They grounded their finding, my Lord, on the provisions of Act 137, 6 and 7. And this is what they had to say, my Lord. This is what the Constitutional Court had to say, my Lord. It is right that once a party challenges the constitutionality of his trial by the trial court, the trial court has to stay all its pending legal proceedings emanating from the impound proceedings until the disposal of the constitutional petition. The operative phrase from this decision, my Lord, is the trial court has to stay all its pending criminal proceedings emanating from that particular section of case. It's our submission, my Lord, that this court is bound by that decision. For reasons which have been explained, my Lord, in the plethora of authorities, my Lord, permitting me as I conclude on that particular point, as far as the rationale is concerned for that particular decision, to refer you then the Supreme Court decision of the Honorable Tewodos Sekikubo and the 3 others versus the Attorney General and 4 others. It's Constitutional Application number 6 of 2013.
Esanyu. Where the Supreme Court had the occasion to state, thus, it is the duty of the court to make such orders as will prevent the matter, if successful, from being nugatory, from being rendered nugatory. It's our contention, my Lord, that if you do not stay the proceedings, the constitutional matter will be rendered nugatory. And my Lord, my colleague, my friend, Mr. Kalibala, has already succinctly explained that. The gist of the constitutional petition, but for emphasis sake, my Lord, just for emphasis sake, that the right to fair hearing under Article 28, which is non-derogable under Article 44, constitutes the first of the matter before the Constitutional Court. So if my Lord is not stay, and it happens that the constitutional petition succeeds, my Lord, there will be a derogation from the right of fair hearing, which will amount to an egregious abuse of Article 44. Most so, my Lord, when the constitutional petition touches the critical issue of the competence of this court, we try to do it. So on the fair, just and reasonable, but my Lord, this honorable court stays the proceedings are waiting this decision of the Constitutional Court. Consider the press imperatives, my Lord, which we have highlighted at the raised in the case of application, which are the thrust of the matter of the Supreme Court. My Lord, on the second order sought, I would like to state, my Lord, that the two orders are inextricably intertwined. The two orders sought are inextricably intertwined. One follows the other. My Lord, once the proceedings are stayed, the next question is, what happens to the accused person is revived? Or revived? Also, when there will be no order for their appearance before court, agree. Because remand cannot be indefinite. I know one will contend that there will be mention. Even if that will be the case, my Lord, that there will be mention of the case, the applicants or the accused person is staying as the audience. And my Lord, your brother Justice Masal Musemi was once faced with that intricate and unique situation. In the case of General David Besigye Mungu versus Uganda, its High Court, its application number 38 of 2016. This is very division, my Lord. I've got the copy, my Lord. My Lord, because of its significance and bearing in this matter, I will proceed to pay before this decision, my Lord. Where Justice Masal Musemi posed a number of questions. There were 7, but I will just read 3 to guide the decision that he made, which is almost on all fours with the present situation. So, however, despite the suspension of the charges, the applicant is on remand and has been directed to apply for bail in the criminal division. Then you ask, this is rather a novel situation which has not arisen before, and there is no known laid down procedure to deal with it. All of that with an application for bail, where charges against the applicant have been suspended or stayed. The crucial question is therefore, does this court fold its hands and send back the applicant on remand in New Zealand, and yet the charges over which he was remanded have been suspended or stayed? And if court is to fold its hands, would that make the order of the High Court by Justice Okubaako Kyebakola? And finally, why should this court fold its hands and send back the applicant on remand? Yet Article 139(1) of the Constitution, along with the Section 14 of the Judicature Act, grant the High Court unlimited jurisdiction in all matters. He concluded by saying on page 5, in the present case, therefore, even if there is no appeal conference from the General Court Martial, because the criminal matter was before the General Court Martial, in the present case, therefore, even if there is no appeal conference from the General Court Martial, this court cannot fold its hands and chase away the applicant from the temple of justice. I shall exercise this court's powers under Article 139 of the Constitution and Section 39(2) of the Judicature Act to consider the bail application by the applicant, and recited Section 39, which, my Lord, under the revised edition is Section 40B of the Judicature Act. By material, my Lord, that particular provision applies in the present circumstances. And the final decision we made, as I read, bearing in mind the law as outlined above, that is after citing the provisions of the Judicature Act, the judge said, bearing in mind the law as outlined above, and in further considerations of Article 126(2) E of the Constitution, which empowers this court to administer substantive justice without undue regard to legalities, I find and hold that the circumstances of this application warrant meritorious consideration. The offences with which the applicant is charged are payable by this court since the proceedings in the general court martial have been suspended pending the disposal. My Lord, General Seducer was accordingly granted bail, cash bail, actually on his own recognizance. Much as I was assured in this matter, as he stated, my Lord, in this particular text, on his own recognizance, 10 million, not cash, just on his own recognizance, despite the gravity of the matter and the fact that it was before the general court martial. So, my Lord, in this particular case, we have gone an extra mile of presenting substantial sureties, of bringing out the profile of the applicants, which are all compelling reasons, my Lord, under the circumstances. But the crux of the matter, my Lord, is not to leave the applicants as lawyers in reason, because that was the issue here. Justice Masawan said I had to deal with. So once you have stayed the proceedings, it's axiomatic that the right to bail has been followed. My Lord, when you do pray that you be pleased to apply, rather to follow this very good precedent set by this very division to admit the applicants to bail after ordering stay of the proceedings. We do so, and my Lord, you have no idea as to when the constitutional court will dispose of the matter. You have no idea. It may take a year, it may take 3 years, or a month, and it's the reason, my Lord, in Article 137, the framers of the Constitution made a command that proceedings be handled expeditiously, but we don't know as to when the matter will be disposed of, and that will be injurious to the rights of the applicants. We do so, my Lord.
In the hierarchy of courts, the Constitutional Court is higher than this court. It's therefore reasonable that this court should give way and order a state awaiting the verdict of the court, of the Constitutional Court. Especially so because the application which has been made in the Constitutional Court emanates from the refusal of this court to recuse itself, the dismissal of the application to recuse, and the court on its heels, the refusal to refer the matter to the Constitutional Court. Justice is about appearances. It should not only be done, but be seen to be done. And the question is what would operate on the mind of a reasonable person following those two incidents? And also the fact of the petition filed by A1 and A2 before the Judicial Service Commission. Would a reasonable person think justice has been dispensed? I would like like to persuade the court not to let any reasonable person think that this honorable court would wish to preempt the decision in this matter. Quickly moving on to the second point, the presumption of innocence, which is in the Constitution, Article 28(3)(a). A1 and A2 are presumed innocent until proved guilty. And the right to bail actually stems from this presumption of innocence. Let nobody go against this constitutional imperative by wanting to imply any guilt on the part of A1 and A2, because the Constitution rejects any such measure. I ask the court not to lose sight of the fact that they have spent 13 months in jail, over 13 months. 1 year ended on the 15th of November, and it's past the 15th of December, so already 1 month, 1 year, 1 month, that we are now entering the second month of year 2. The court should use its inherent jurisdiction to grant bail, noting the lengthy time this matter is taken, and also to take into consideration the age, especially of A1. And age is one of the considerations in bail. Whether they are like this, I just want to comment that the bail, not the bail, but the application, the documents that connect to the application, especially the supplementary affidavit of A1, shows that he had previous cases of treason. This is not the first treason case. In both cases was admitted to bail. And both cases he attended court as required until the prosecution. And that brought the case. Until the conclusion of those cases, whatever of the way. And therefore, he has no criminal record. None of them has a criminal record. And just to describe what advanced age means, it means anyone of 60 years above. I therefore myself qualify as advanced age, and A1 qualifies as a person of advanced age. And A2 as well. So really, the court ought to be persuaded by this fact. Finally, and before I go to the final, I've been looking at 126, exercise of judicial power. To begin with, it's the right from the people and shall be exercised by the courts established under this Constitution in the name of the people, in conformity with the law. And that is why appearances matter. This court is accountable to the people of the country. The prolonged incarceration of both A1 and A2 is causing great concern. I can say that from the back. It's a matter of public notoriety that the highest authorities in Uganda have expressed concern about the prolonged incarceration, and I'm urging not to take judicial notice. But none other than His Excellency the President of Uganda has expressed concern. It's been in the papers. So I can say confidently, standing here, that the people of Uganda, including the people in this court, are very concerned about the prolonged incarceration. I would urge you, because this case is right, for grant of bail. I am impressed by the sureties presented, and I'm urging the court to be persuaded that suitable sureties have been presented, and that for justice to be done, let A1 and A2, let them not spend a second Christmas in incarceration. That will go against the presumption of innocence. I pray that the court exercises discretion in the case and grants bail. And I associate myself with what my eminent team at the British Secretary.
My Lord, for record, from Richard Billy to the Secretary. For the respondent. My Lord, the issues under business application number 814. Should be, in our view, whether or not this court can stay proceedings before it, or proceedings under session case number 335 of 2025, and whether there are any remedies available, any other remedies available to the applicants. My Lord, the applicants filed this application premised on constitutional petition number 031 of 2025, which was annexed in Mark B. My Lord, applicants expect you to read that petition. And assume
that all the contents therein are true, which shouldn't be the case. Having filed constitutional petition number 0331 in the Constitutional Court, which we believe and agree with defense for the applicants that it is higher than this court. They should have advanced these same arguments, presented these arguments, which unfortunately are not so convincing here to the Constitutional Court. Because the Constitutional Court has control over that petition, which unfortunately this court doesn't. It will therefore be an act of insubordination, in fact, just to emphasize, for this court to think for the Constitutional Court. Because it is the Constitutional Court that has a duty even to think about the possibility of success of that petition. It's not this court. It is the Constitutional Court that can determine when the petition number 039, will be heard and completed. It's not this court. It is unfortunate that whereas that petition was filed against Attorney General, this application 03814 was filed against Uganda DPP party. These are two different parties. It's just rational that the party who actually is part of the constitutional petition should be the same person who even argue the state. This court can only stay its proceedings if it has referred a certain matter or it has made a reference to the Constitutional Court. My Lord, if that was the case, then we wouldn't be trying anyone. If that was the case, every person would be running to the Constitutional Court, file a petition, and then, if I'm quoting my senior brother, Bayinza Okubaako, that to stay of execution, the stay of execution where there is a reference, I mean where there is a constitutional petition, is a command. In fact, if that was the position, which unfortunately my senior colleague has misguided his court, then we wouldn't be trying any person everybody would be finding a way, of getting the constitutional court and avoiding proceedings against the contract. Whether or not even the applicants admit an application in the constitutional court, it is never a command, it is a discretion. My Lord, you recall very well this same application if you recall very well, on the 6th of November 2025, but I can take you back to my Lord on the 1st of October. 1st of October 2025. There was an application for stay of proceedings. And on the 6th of November, this court dismissed that application. So this application, application number 814, is a replica of that application, my Lord, that would invite this court to take judicial resolve, that was dismissed. The only difference is that by then, there was no constitutional petition. But my Lord, the respondents, I'm glad that counsel for the applicants took the guidance of prosecution, not the respondents, where we argued that they should have filed a constitutional petition, the constitutional court. We are glad, we appreciate that. But we still guide, my Lord, that they should go to the constitutional court and file an application for stay of session case number 335 of 2025, not in this court. This application is misplaced, and this application is an abuse of the legal process. And the purpose of it all, my Lord, is to frustrate the trial. Completely to frustrate the trial. Allow me, my Lord, just give you a small background. On the 26th of August 2025, this matter appeared in this court for scheduling. And my Lord, the accused persons never appeared in court on that day. However, prosecution was ready to proceed with a pre-taking and scheduling. Remember that day, so the senior counsel Panga who appeared in court. On the 1st of September 2025, prosecution was ready to proceed with this case. However, it was only A3 who was in court. A1 and A2 did not appear in court. And on that day, my lord, the trial judge informed this court that A1 had written a note or a letter informing court that he was not well and therefore was unable to attend court. This background, my lord, is to show you how the defense or how the applicants are actually frustrating the trial of this matter using the weapons that are at their disposal, which include multiple applications. My lord, on the 1st of October, 2025, as prosecution was ready to proceed with the scheduling and pre-taking, applicant number 1 suspended his lawyers temporarily and opted to speak for himself, which this court didn't allow, but directed that he writes all his concerns in a letter and file it by 3rd of October 2025. And that's when the court will respond to the contents therein. On the 8th of October 2025, all the applicants were in court, and the prosecution was ready for pre-taking and scheduling. However, the accused person, all the applicants made an application for this matter be referred to the International Crimes Division of the High Court, and therefore this court never had jurisdiction. They also made an oral application to have the trial judge recuse himself on grounds of biasness and incompetence, among others. On the 15th of October 2025, as the matter came up for ruling, that application, all applications were dismissed summarily. And the prosecution made an application to have the accused person take plea and schedule. Instead, the applicants made an application for reference and stay of the proceedings. 5. Criminal Section Case Number 335 of 2025. In that application, my lord, the grounds were almost the same. And the very court take insurance of it. On the 6th of November 2025, this honorable court, in its wisdom, dismiss the application or applications for reference and stay of session case number 335 of 2025. Prosecution informed the court that they were ready to take plea and schedule this matter for hearing. But on that particular date, my lord, if you remember, this court remembers, one of the previous sureties for A2, for applicant number 2, attacked the judge. Even attempted to attack prosecution. Actually, taken prosecution. It was an open thing, we don't need any evidence. Someone to say no. She was here holding the microphone. We survived by just God's grace. We're almost coming with thought of coming with helmets. A big loss of eyes and other parts of the body. Here, my lord, prosecution still informed the court that they were ready to take plea and schedule the matter for hearing. And we thought our colleagues had put the guns down. So at their instance, in all those cases, my lord, that judgments have been at the instance of defense, all the applicants. On that day, my lord, they prayed for an adjournment. And the matter was adjourned to the 4th of December 2025. Prosecution informed the court they were ready to take plea and schedule the matter for hearing. The applicants informed the court, however, that they had filed constitutional petition number 031 of 2025 and miscellaneous application number 814 of 2025, in which case, my lord, this court gave credence. Hence, today's hearing. The issue now comes in. Isn't that the process of frustrating the trial? And can that be attributed to prosecution? That frustration there, can it be attributed to prosecution or defense? We beg this court to agree with the respondents. The respondent that this delay, frustration, is intended to frustrate the trial. So it is absurd for anyone to submit that the applicants have been over-detained without being objective and without reflecting on the history of this case before this court. And those are the same tricks which were played in our Chief Magistrate's Court, where the defense lawyers, my lord, left the court in protest, or even frustrating the committee of evidence. What is the constitutional? I mean, now, this application is part of the larger, it's part of the game to frustrate the trial. How have courts, my lord, dealt with such a situation? My lord, your brother, your senior brother, Honorable Justice Sekana Musa, as he was playing in the High Court, in civil suit number 94 of 2021. You know, my lord's prosecution is a bit courteous. My senior colleagues were submitting, were not giving us authorities, they were giving out. Civil suit number 94 of 2021. My lord, a copy of which is here for control. My lord, the parties were His Excellency Yoweri Kaguta Museveni versus the editor-in-chief, Daily Monitor newspaper, and Monitor Publications Limited. An application such as this one, my lord, was made and your senior brother everybody interpreted the law and dismissed it. My lord, allow me just to go through a few things in that judgment. The judge, among others, said that this court should not stay its proceedings simply because the defendants have decided to file a constitutional petition. By allowing a stay, that this court, and in the circumstances this one, my lord, would have abdicated its responsibility and duty to hear the prosecution's case against the applicants. He was saying so with approval of Honorable Justice Morenga in the constitutional petition number 2 of 2002 Charles Onyang Obo and Andrew Menda versus Attorney General. My Lord, we shall not repeat that quotation, but it's very imperative, very important to make by that church. My Lord, very important to note, on page 4, should be third paragraph. In the case of Geoffrey Kazinda and Attorney versus Attorney General, constitutional petition number 50 of 2012, it was observed as below, and I quote. However, where a party to the proceedings before a court of law, where a party to the proceedings before a court of law, petitions on his or her own, like the applicants here, my Lord, did, to the Constitutional Court on to have, or rather, my Lord, to have the Constitutional Court determine some question, to have the Constitutional Court determine some question to do with the proceedings, to do with the proceedings before that court of law. It does not automatically follow that the court has to state the proceedings before it. Pending the determination of the question a party to the proceedings petitions the Constitutional Court to determine. My Lord, allow me quote a very rational paragraph or quotation from the case of British American Tobacco, which your senior brother quoted in his ruling. The British American Tobacco Uganda Limited versus Fred Mwema and 4 others. Civil suit number 751 of 2014. Honorable Justice David Wamtusi stated as below. If it were otherwise, then angry litigant trying to delay proceedings would rush and file proceedings in the Constitutional Court. This would heavily clog not only the Constitutional Court, where the petitions would be filed, but also the High Court. Because the cases before it would be brought to a halt, and yet findings continue daily. If there was any situation where the president relates direct, then it is this situation and this situation, my Lord, that we have cited. We appreciate, my Lord, that this ruling is not binding on you, but it is extremely specific. And we write you, my Lord, to take it into consideration. As if that's not enough. My Lord, in the case, in the constitutional application number 9 of 2023, Honorable Nandu Agnes versus Attorney General. My Lord, the Constitutional Court took the same view as in civil suit number 094 of 2021, while dismissing the petition, the application by Honorable Nandu. My Lord, the copy of the ruling is here for legal purposes and also proceed with defense. But next time they keep on giving us the authorities as well. My Lord, I refer you to paragraph 14 of that application. Where, my Lord, the Constitutional Court quoted or relied on the Constitutional Petition number 10 of 2008, Jim Muhez and 3 others versus Attorney General and the Inspector General of Government. Court, my lord, caution against the court, caution against the stopping of criminal trials. The stopping of criminal trials on allegations that's the paragraph 20, my lord. On allegations that the trial would not be free and fair. In fact, my lord, that court empowered this court. How? In the same paragraph, the trial court is capable of fairly, the High Court is capable of fairly and accurately pronouncing itself on the matter without prejudice to the accused, and in this case the applicants. Where any prejudice occurs, the appeal system of this country is capable of providing a remedy. Was it to be otherwise? Was it to be otherwise? A situation would arise where everyone charged with an offense would rush to the Constitutional Court with a request to stop the prosecution pending hearing his challenge against the prosecution. In due course, this court would finally, this court would find itself engaged in petitions to stop criminal prosecutions and nothing else. But the really the wise judge. You continue. This could result into a breakdown. This could result into a breakdown of the administration of the criminal justice system. This could result into a breakdown of the administration of the criminal justice system and affect the smooth operation of the Constitutional Court. And my Lord, the court emphasized that the applicant has enough remedies available at the end of the determination, at the end of the determination of the constitutional questions before the court, which are not limited to quashing the criminal proceedings, and or declaring them unconstitutional. My Lord, this is a matter, this is an application of 2023. My senior colleague, Elias Okubaako, is determined to convince this court on the constitution of 2013, when there is one of 2023. We invite court, my Lord, to find that his authority in the name of Basajja Baraba Hassan versus Attorney General is inapplicable. They are not addressing themselves to the new case law. My Lord, I will have given a copy to the defense. My Lord, therefore, we invite this court to find that authority, my Lord, is binding over this court in that respect. But also, authorities aside, my Lord, the applicants in an application such as this one should have, for all intents and purposes, demonstrated the effect of a nanny-state on their trial. They instead, my Lord, sought to rely on Constitutional Petition number 031 of 2025, where they purported, my Lord, put or demonstrated how, if there was no stay, the applicant would not get a fair trial. A petition which this court is not privy to. The defense or the applicants, my Lord, sought to rely on the program system and then a communication from the Honorable, the Deputy Chief Justice. To convince you, my Lord, or convince this court that Constitutional petition number 031 of 2025 may take a long period of time before disposal. My Lord, that submission is redundant, and we beg this court to treat it with redundancy it deserves. Because the consumer of that kind of submission is the Constitutional Court, not this court, my Lord. My Lord, suffice to note is that your hands are tied. Your wrist will cut. You made a decision on this application. You made a decision on this application, my Lord, and we invite you to take judicial notice of the ruling where you actually, my Lord, your Lordship, dismissed an application by the applicants to stay criminal session number 335 of 2025. And my Lord, if this court agrees with the respondent that its hands are tied, then there is only one remedy: to dismiss the application. This application is a disguised appeal, which is nowhere in the procedures of the law. You can't appeal to the same court. And this is not an application for revision. It's not anywhere, my Lord. The authority submitted by my senior colleague, Karipara, Mr. Karipara, and Your Lordship, of Okubaako Kyebakola, my Lord, Onyamboko, my Lord, sorry, my Lord, Your Lordship, does not apply in the instant case in respect to the application. But we agree with the defense, all the applicants, that this court has discretion. Under that law, cited, that is section 37 of the Judicature Act, this court has wide discretion. Unfortunately, that discretion does not apply here. It will only apply if the applicants were seeking a constitutional reference. Yes. Stay of proceedings where there has been a reference to the Constitutional Court, not where they have on their own filed a constitutional petition in the Constitutional Court. My Lord, if this court agrees with the Constitution, then even the application for bail collapses wholly. If it is true that, I know if I'm to borrow the submission of Senior Counsel Mr. Fago Elias, that these two applications are intertwined. My understanding would be that it would be left to the discretion of court, but the whole application that should have been presented before court is the application for stay, if they are intertwined. As submitted by given the circumstances, my Lord, where the applicants filed the constitutional petition number 039 in the Constitutional Court, in the circumstances, and they are seeking the stay of proceedings of session case number 335 before you, my Lord. The two are not related at all. My Lord, much as the applicants have withdrawn even application number 282 of 2025, the letter, my Lord, which was filed on the 19th of December 2025, it was, my Lord, as a result of the respondent my Lord, filing an affidavit, my Lord, of Tom Henry Joseph. And that affidavit, my Lord, under paragraph 20, 21 actually, my Lord, we alerted defense for the applicants that that what amounts to an abuse of the legal process. Because this is application number 282 of 2025, before it was withdrawn, my Lord, today, was seeking the same remedies as Mrs. application number 814 of 2025. So in effect, my Lord, Your Lordship, this withdrawal was a diversion. My Lord, I would wish to remind this honorable court, my Lord, that on the 4th of December 2025, the trial judge labored to ask the applicants to withdraw actually the status of 282 and its status, my lord, but they insisted that it has to stay. We only walk them up in an affidavit of Tom Henry Joseph, my lord, which we filed and served.
My lord, we are also going to object to that line our friend is saying. My lord, indeed, we have been patient. He's indulging in the case of the evidence. If a matter has been reviewed, it's not on record. So he did not object to the video. You have the occasion to reason the way he's reasoning now. At the time we made the application, we withdraw. So the matter was able to rest. He's accusing us of delaying the proceedings. He's playing the same. He has been submitting for an hour. My lord, we pray that you direct him to close his submissions, we rejoin, and we get a ruling. We do so,
My lord.
This application is going, but just
Most obliged, my lord, we had even finished submitting on that. On the issue of bail, my lord, submitted by the applicants, we beg this court, my lord, to dismiss it as well. My lord, your lordship, the applicants sought to rely on the ruling of your land's sister in criminal business application number 113 of 2025. On the ground that she had found the sureties for the applicant substantial, or rather that they had fulfilled all the grounds except interfere, the hospital interfered with the investigations. Your Lordship, our submission is that issues of bail applications are discretional and circumstantial. The ruling, my lord, your lordship, under business application number 113 of 2025, at that time, even if it was yesterday, it does not bind me. Because different applications present different facts. For example, last time, the applicants produced different sureties in number as compared to today. So the decision in criminal business application number 113 of 2025 does not apply, because we are not talking about the same sureties. And same letters of introduction. Besides, my lord, your lordship, your lordship, we shall tackle one ground at a time. My lord, on the issue of sureties as presented, my lord, we beg this court to find that those sureties are not substantial. The reason, my lord, is that they all subscribe to A1. A1 is their master. And therefore, one or the other, and it's their superior, and therefore, it will be really extremely hard for the sureties to compare.
The reluctant side, which object to that, unless even as an affidavit, you cannot testify from the bank saying that you subscribe to A1. Where's the affidavit?
You can respond in doing that. So far, my lord, it would be hard for sureties to compare and influence the applicant, my lord, your lordship, to appear in court unless the absconded player. My lord, for A2, he has presented one cattle is a Tare. Was a brother but an uncle. But there is no proper definition of this gentleman called the Kato Mr. Utari. Whether it's a paternal uncle, whether it's a maternal uncle, we don't have the word uncle. There must be either paternal or maternal uncle. Then how are we going to trace him in case he does not perform his roles? And apart from being introduced as a surveyor, what does it mean to be a surveyor? Does it mean that you have to gain full employment? You see, my lord, we are talking about who a substantial surety is. There are several, one has to contextualize who a surety is. This is a serious matter. The applicants are charged with the treason and misprision of treason. You can't just bring someone because, first of all, there's no proof that it's a survey. These are treaties, my lord, your lordship, where it will be a struggle to trace them and also to compare the applicant in case he never or he has gone in vain. There is no way, your lordship, that we can differentiate between a surety and his financial capacity. Because they're normally bonded. Without proof of which, my lord, or your lordship, the person or the shooter is not substantial. He has to prove gainful employment. Your lordship, the second shooter also produced one high Bautare Nagita, the wife. Even my lord medically, a wife is supposed to submit to the husband. Medically, even the Quran. So our submission is that if this application is granted, it will be hard for a wife to compel the husband who is supposed to go out there look for funds to cater for a family, my lord, to appear in court in case he absconded.
Again, I'm just wondering, my lord, should we really listen to this insult upon women? In which era is the boom
We are about to finish up. But also, my lord, they introduced her as a businesswoman. We don't know what she does, because her introduction as a businesswoman was intended to add flesh to her name. But prostitution and this court was left in a dilemma. Who are business? What business? Because being a businesswoman is not a profession. It's not a profession. My lord, the defense, the Africans have completely failed to demonstrate that their treaties are substantial. My lord, on the ground of antecedents, of the applicants, my lord, council submitted that the applicants are 69 and 66 years respectively, which we don't dispute. But being a person of advanced age is not the only ground that this court considers in grant of bail. The constitutional petition, my lord, which they banked on, the constitutional petition, my lord, which they banked on, my lord, to put it as another ground, my lord, is so speculative. So this court, my lord, cannot rely on that as a ground. But that one, my lord, is on assumption even then. Is on assumption that this court has granted license application number 814 of 2025. And it is in the same ground where the submission by my senior colleague, Mr. Okubaako, yes, the submission of the authority of High Court license application number 38 of 2016. That is General David Besigye versus Uganda. Was brought in. The submission is still redundant. For short of words, my lord, we pray that this court considers it as inapplicable. But this application will have been superb if the stay of execution was granted. The stay of proceedings, my lord, was granted. But the fact that we are arguing the same application for stay of proceedings, it perplexes, frustrates to hear. Counsel for the applicant citing this authority. It is too early for it, my lord, your lordship. Your lordship, on whether the accused persons are likely to commit other offences if released on bail, my lordship refer you to the affidavit of Joseph Tom Henry, paragraph 23 of that affidavit. That is for A1, my lord, your lordship. My lord, your lordship, it is not true that the applicants will not commit other offences if released. The first applicant has a good record of that. He's confrontational, and in fact, the moment you release him on bail, he will start from where he stopped. And you commit other offences while on bail. Like, as we fight paragraph 23. There's an annex.
My lord, I think Philippine has to be stopped. If he wishes to be a witness, I would only be too happy to cross-examine him.
Paragraph 23. In specific paragraphs 15 of the first applicant affidavit support, the applicant committed the current charges by Nakawa criminal case number A008 of 2025, while on bail by Uganda Road criminal case number.
I still object because the Nakawa case has not been tried. This tramples the presumption of innocence. You cannot say but can he say that he committed offenses? There's an allegation. Can he prove
My lord, our submission is that they will commit other offences in case this application is granted. Your lordship, on whether or not the applicants will interfere with witnesses or investigations, we also refer you to the affidavit. The the applicants are highly educated people. And they have a wide network which they have built over time politically. And it is that network, my lordship, that the applicants will use, interfere with our witnesses who are separate. We also want to just to say something still on the surety. My Lord, given what happened in this court, that was one of the sureties whom your sister under the business application number 11 of 2025. I'm submitting my order. Whom your sister just came here. The surety who fought wanted to attack the judge. My Lord, we withdraw it. We withdraw it, my Lord. In circumstances, my Lord.
Panangeza kudata, pananga kudata.
My Lord, in the seconds we will beg this court to dismiss the application of stay of criminal session number 335 of 2025 and release of bail. And we pray, Your Lordship, that this court be pleased to fix session case number 335 of 2025 for plea-taking and scheduling, because it will have no effect or impact on constitutional petition number 031 of 2025. It's open.
It is generally the law that where you can seek remedies from full courts, have a hierarchical relationship. You first seek that remedy in the lower court. In the Constitutional Court, petitions and references rules, it is stated in Rule 23 that the Court of Appeal rules apply to constitutional petitions. And Rule 42 of the Court of Appeal rules makes that clear point that if an application can be made to courts, the High Court and the Court of Appeal, the Constitutional Court, it should first be made in the High Court. So I think we are in the correct forum to seek stay. My Lord, to just read from the authority that my learned friend cited, the one of Joel Museveni and Craig Monitor. My learned friend left out, I think he may have forgotten to read the Jamhuri. I'm not accusing him of leaving it out. But at page 4, the judge citing Kazini said that in such a case, the issue of whether or not to stop proceedings pending the determination of the petition appears to be left to the discretion of either the trial court, in our case is the High Court, or the Constitutional Court. So the detail of it is that if a party files a petition just like this one, it is pending, the decision is left to either this court or the other court. It is not limited to the other court, and this court is not without power. My Lord, it has been argued that this application is filed against the wrong party. This application, that it was filed against the wrong party. There was mention that it should be the Attorney General. My Lord, the respondent is aware, I am sure, that Article 250, sub-Article 4 of the Constitution says that in the title of any criminal proceedings, prosecution shall be designated by the word Uganda. correct party where the prosecution is a respondent. Not criminal application. Therefore, criminal proceedings, the correct party. Perhaps if you had said versus DPP, the argument would have been useful. My Lord, Charles Onyango has been cited by both sides. Madam Faith has argued that it was a reference. And the premise of his argument that it was a reference is because it was cited by Justice and said to be a reference. My Lord, it is common knowledge that matters before the Constitutional Court are either constitutional petitions, constitutional references. And the titles show what they are. The title of that case says it is an appeal from Constitutional Petition 15/1997. Not constitutional reference. Just like this one is a petition, not a reference. My Lord, we reiterate that that authority is only applicable in this matter. It sets guidance that has never been departed from. My land friends have not cited any Supreme Court saying Onyango was wrong with the side. They have been swaying in the lower courts because they cannot reach above those courts. They have been oscillating between the High Court and the Court of Appeal. Onyango is very clear on the circumstances we find ourselves. The applicants have been accused from the bar of many things. So even when they were unwell, they were expected to come here so that you respond. Can examine them, perhaps, see if they were unwell. But thankfully, my Lord, on the occasions where they have needed okay, the power and the discretion has been in the court and not the respondents. But my Lord, the intention of all that narrative suggest that this is an attempt to delay trial. Contrary to an attempt to delay trial, which is an attempt to ensure a fair trial. Whereas the state is interested only in the trial, the applicant side is for a fair trial. My Lord, what the Constitution expects is a fair trial, not just any trial. So related to that, it is a fact that the accused have been incarcerated for more than 1 year. They are starting the 14th month as we speak. Done about the 14th month. Looking at how things unfold, the Constitutional Court, they will remain incarcerated for many more months while they try to secure their trial. My Lord, in exercising the court's discretion, the fair and proper thing is to stay proceedings until one day. They have hopes they need not continue to burden the state. The other side, where it is congested, at least they will free up the space for Adamus Nadutu did not overrule Charles Onyango. It was a civil case. It was not about liberty, but also the proceedings, but the application was of a civil nature. It was not about liberty or fair hearing. Certainly, it wasn't challenging the tribunal itself, which is where we are. Big. My Lord, when you read it, it appears to read more on the law of temporary functions in this consideration. My Lord, I applaud the respondent for accepting that the wide discretion the court enjoys is available. But I hasten to add that the view that such power is only available if the applicants are seeking a reference is erroneous. Although the text of section 37 is very clear, it has no such limitation. So, in rejoining on the matter of stay, my Lord, pray that the objections raised by the respondent be overruled. And to borrow the words of my learned friend Mr. Bivumbuka, find them all redundant. Not useful in that way. My Lord, on the matter of bail, one friend indicated how connected, intertwined these orders are. And it is true that they are that intertwined. So, the court were to find in favor of the applicants on the first order assault. The second one should ordinarily be fought. Lord, we made reference to miscellaneous application, the ruling in miscellaneous application 1/2025. The ruling in miscellaneous application 1/2025, the decision of Justice Time. Lord, we did not make reference to it so that the court would just report the findings about sureties there, but to demonstrate that their substantiality has been efficient in the single law. They have been found to be substantive for those same accused persons. My Lord, the sureties are not fictitious, they are present. They all stood up one by one. The state, you have asked many of the questions that have been asked. They chose to keep quiet. In their place, they know that these are substantial. So, my Lord, we are again humbly praying that you find those issues presented as substantial. The idea that one must have a lot of money to be a surety, I think would exclude maybe 99% of that. The idea that one should be a professional to be a surety is even dangerous because we have a profession called surety at some point. Because a surety is simply a person who is in a defined relationship with an accused person of such a nature as would enable them to discharge their obligations towards the court. Their profession is not important. To assume that they must be rich is to assume that they will be told to pay cash loan of unimaginable amount. Yet courts also release applicants on non-cash loan basis. And my Lord, on the matter of the second applicant's Second surety is one. It is appalling fact that such a sexist, gender insensitive submission will be made in respect of the wife of the king. Although the bail guidelines have not stated anymore that sureties must not be spouses